Good morning, WTOB listeners. I'm attorney Dylan Greenwood here with attorney Harold Eustache on For the Record with Greenwood Law. Thanks for joining us here this morning. Before we get started, as we've been announcing and talking about it, court is getting more and more back in session. Please, if you or someone you know has anything, whether it's criminal, civil, whatever it may be going on in court, it's really, really important to check court websites, clerk websites. Forsyth County Clerk of Court has its own clerk's website that has a lot of information and updates for the general public. And if you got an attorney in your case, be in touch with that attorney for sure, because there are a lot of changes. We've been talking to a lot of people about them as they've been coming about, but it's just really important. That way there's no risk of any missed court dates or anything like that, and try to get certain things moving. But today we're excited to discuss with everyone probation and probation violations and that sort of thing. A lot of people that we've talked to before who may or may not be as involved in the criminal justice system as us, that we see it every day, and we see the impact of what this has on people's lives every single day. And a lot of people, will bring up, oh, well, they got off easy. They got probation. You must have done a really good job. You got on probation. And yeah, we might have done a good job by getting on probation as attorneys, but probation is not always an easy thing. And it's not an easy thing for a lot of people.
No, it really isn't. And sometimes, we wonder, is there a cost-benefit analysis with probation, because it can be very restrictive in taking away some of the rights that people have, and putting a lot of terms and conditions on that person that can, sometimes be hard to satisfy for a person. So a lot of times what happens when a person is sentenced in court, they will hear something like this from a judicial official. Let's say a person pleads guilty to misdemeanor larceny, and a judge might say, well, upon a plea of guilty, there's a verdict of guilty. That person is sentenced to 120 days in custody and Forsyth County Detention Center. That sentence is suspended for 24 months, and that person's to be placed on supervised probation under the following conditions, and they'll list those conditions. Now, that may sound like a lot of mumbo jumbo to somebody. So we have to explain it to clients. So what do you normally say?
Well, I'll just tell you that, when I was first sitting in court in law school and I heard that, you kind of hear that and you go, well, what just happened? Well, they got sentenced to jail. No, they didn't. And a lot of times when we have a client that maybe gets sentenced to something like that, or they hear those words, they're leaning over and they're going, what's going on in my case, Mr. Green? What did the judge just say? And you always kind of have to be like, just be quiet for now. Let me hear what the judge says, and then I promise that I'll explain every bit of this to you. And that, that conversation that you have after that is, one, you need to calm down. You're not going to jail today. When you have a term of imprisonment that is suspended, then that's when probation comes in. And at that point, a judge can either put someone on supervised or unsupervised probation. And those are two different things. And supervised probation is where you have a probation officer that you have to check in with. That's the gist of it. There's a little more to it than that, but that's what it gets down to. That's what you have to do. Unsupervised probation, you don't have a probation officer. You have to comply with the terms that the court sets out. But the main thing is you comply with those terms, you stay out of trouble. At the end of the time, you're going to be fine. Pay your fine, you're going to be fine. And you always just kind of have to go through and explain just what all that means for somebody. And when you're going through all those terms that someone has to abide by on probation, and they start racking up, because there's 15 of them that are pretty standard throughout probation itself. Some of those don't necessarily apply to unsupervised.
Right.
But in supervised probation cases, there are actually 15 factors that person has to abide by unless a court specifically waives those in that case.
Right, and some of them are more restrictive than others, but generally it's just, they can't commit a new offense, have to remain within the jurisdiction unless given permission. That's on supervised probation. Have to report to their probation officer, satisfy any financial obligations they have, can't possess a firearm, they have to pay supervision fees and remain gainfully employed or in school.
Cannot abscond.
Can't essentially. We're going to talk about absconding. One of the main ones is they're subject to warrantless searches and seizures, and by law enforcement or probation officer, which is still law enforcement. And that's important because if a person is stopped or anywhere, they can be searched, and they don't have to. There doesn't have to be probable cause to search that person. So. It opens a person up.
That's in your home. That's in your car. Vehicle. That's your person.
Yep.
Every bit of that you've given over that right by being on probation, and I think a lot of people, we talk to people all the time that will get charges for something, and you're going through and you're talking to them about it, and then at the very end of the conversation they go, "Oh, well, by the way, I was on probation at the time." So all those things that you're going through in your head and analyzing and going, well, you might have gotten searched without a warrant. There might be a Fourth Amendment issue here. And then all of a sudden it gets mentioned, oh, well, I was on probation. You go, okay, right. That whole analysis is thrown out because being on probation, you're subject to that.
Right. Another important regular provision of probation is person cannot use, possess, or possess any controlled substance or illegal drug. And at first that may sound obvious, that's already illegal. But actually, the use part is not a criminal offense. It is not necessarily illegal to use a controlled substance. There's no statute for that, but it is illegal to possess one. But under this, you can be violated for using a controlled substance. So that the way that looks on probation, on supervised probation, is you would be subject to drug tests, and if you fail those drug tests, it could be a violation of your probation.
Mm-hmm. And violations can happen for supervised and unsupervised probation.
Mm-hmm.
I will say, typically in an unsupervised probation context, the violations typically come down to not paying money.
Right.
That is the absolute most common. Every now and then it'll be because someone didn't do community service or that someone didn't do like a substance abuse assessment. Very rarely, though, is that actually caught and violated. The money thing, though, is a thing. That will almost always get caught and subsequently violated. And so while you got this great opportunity to be on unsupervised probation, where you didn't have to constantly check in with a probation officer and all that stuff, if you don't pay that money, you can still be violated.
Oh, yeah.
And then if you're on unsupervised probation, again, that's also, you got to pay money, except there's more money on supervised probation as opposed to unsupervised, because being on supervised, you have to pay supervised probation fees, and you pay them every month to the state of North Carolina for them supervising you and checking in and doing the drug tests and doing the potential searches and seizures, and really depending upon what you were convicted of usually determines the approach that a probation officer will take.
Mm-hmm.
So let's say you're convicted of a drug offense. You can pretty much guarantee that you're going to get drug tested.
Absolutely.
If you are convicted of a breaking and entering, burglary, and somehow you got probation for a burglary, or a larceny, like a felony larceny, any kind of felony offense like that that's non-drug related, there's a decent chance that at some point in your probation, there's going to be a warrantless search. I've seen it many, many, many times. They definitely key in, and law enforcement agencies talk to probation.
Oh, yeah.
If they're keying in on particular individuals, they'll see them, whether or not they're on probation, and sort of create an opportunity for there to be those opportunities
Absolutely.
for warrantless searches and seizures.
It is, again, it can open a person up to a lot of potential liability criminally.
That's why we have some of our clients that tell us, if it's not that much time, I'll just do the time.
And when I was on the DA side, I would sometimes question, why people wouldn't take time. There is this sort of thing where people are very afraid of being put in custody, and I totally understand that. But sometimes if you're 7 days in custody versus a couple of years on supervised probation, that's a tough ask for a lot of people.
Especially when you're looking at $40 a month in probation fees if they're not waived.
And those things mount up, and we've seen it a
Yeah.
million times on violation reports where a person has to pay restitution, pay supervised fees, pay their court fees, pay fines. I mean, those things are just mounting up over time, and it can be a lot for a person. So I know we talked about violating probation. What are the different ways that you could violate probation?
Well, violations of probation can happen in one of two ways. You have substantive violations and you have technical violations. And substantive violations are really your most serious violation. That's absconding, that's committing a new criminal offense, and or having 2 prior periods of confinement in response to a violation. And that is referred to as a CRV, confinement in response to a violation. And if you have 2 of those prior things, you can get a substantive violation. A substantive violation makes someone eligible for revocation of their probation. So what does that mean? That means that, just like when Harold started this off, he said the sentencing judge says 120 days active, suspended for a period of 12 months. Well, the reason the judge has to start off and say 120 days active is so that if you violate the probation, it comes back to that the judge looking at that has a benchmark to say, well, okay, if you violate it so bad that we have to revoke, that's the sentence you're going to get. The judge who heard all the facts from the prosecution, all the mitigating factors from the defense attorney, and made that determination is in the best position to come up with the actual sentence in the case. And so based off of that line of thinking, the judge, the original judge, is the one that's determining the period of active time. And so if you get revoked, that's the period of active time you would likely be serving. So the substantive violation certainly makes you eligible for that. But technical violations are something different, correct?
Yeah, they are. Technical violations are essentially any violation that's not substantive. And so that can be many, many different things. So if you remember earlier, we talked about some of the regular conditions of probation. And so if you violate those, that would be could be a technical violation. Or there can be special conditions of probation. For example, if that person that was convicted of misdemeanor larceny and the judge gave them a suspended sentence, the judge could also add a special condition of probation, like writing a letter of apology to the merchant. And that would be added on to the judgment. That would be something that the probationer has to do as part of their probation. Now, if they didn't do that, that would be a technical violation. And these technical violations, they can't necessarily revoke your probation, but they can subject you to a quick dip, which is essentially a confinement in response to a violation. And, so you could do 2 or 3 days in custody. And if those things add up, that could be a substantive violation there at that point. So a lot of times when we see violation reports, the types of technical violations would be, failure of a drug test, failure to pay fines, failure to report, which is not absconding, and we'll get to that in a little bit. But one of the main substantive violations we see the most often, well, it's 2 that we see the most often, but the first one would be absconding. Mm-hmm. And we can talk about that.
Yeah, absolutely. And absconding is, I think the best way to put it, it's critiqued a lot.
Sure.
What really is absconding? I think a lot of people would think of absconding as leaving the jurisdiction. So if you're on Probation in North Carolina, supervised probation in North Carolina, you're not supposed to leave the state of North Carolina. And I think most people, regardless of their exposure to the criminal justice system, understand that concept in some way. That if you're on probation, you're not supposed to leave. Supervised probation, you're not supposed to leave. But that's not absconding.
Right.
Absconding is different, and North Carolina courts have said that that occurs in two ways. The first way is willfully avoiding supervision, and the second is willfully making your whereabouts unknown. So, Harold, this is your area of expertise. I know that.
Absconding has been highly litigated area of the criminal law, one of the most litigated areas of the criminal law, and the courts have gone back and forth to define what absconding is and isn't. One of the best ways to think about it, I'll use an example here, where if a probationer misses an appointment with a probation officer, but the probationer has attended, let's say, their last 2 appointments, but they missed this one, and the probation officer attempts an in-home visit, and when the probation officer goes to the home, a person answers the door and says, "Hey, that defendant doesn't live here anymore. They moved a couple weeks ago." And then the probation officer goes out and files a violation and says they absconded. Now, would that be absconding? Probably not. Probably not based on those facts. Even though the person did fail to report and wasn't, at the home that they said they would be, the courts have said, one, that failure just to failure to report to the probation officer 1, maybe even 2 or 3 times isn't quite enough to say you willfully are avoiding supervision or making your whereabouts unknown. There is a different technical violation for failure to report or for just missing a meeting. That's different than trying to hide. There's a willfulness in absconding. And also the courts have said that a probation officer has to really put in quite a bit of effort into making sure and investigating whether or not this issue with a probationer is willful. So a lot of times you'll see probation officers call homeless shelters, they'll call hospitals, they'll try to talk to friends and different neighbors and try to really do due diligence to see where the person is. The other piece of that is, if a probation officer knocks on a person's door and let's say somebody answers the door and says that the probationer is not there anymore, the courts have said that if the identity of the person who answered the door isn't known or isn't given to the probationer in a subsequent hearing, that can't be used for absconding because the probationer doesn't have an opportunity to really confront that person. And, frankly, the person answering the door could have all sorts of motives to say that probationer doesn't live there. And it's tough to say that alone is enough for willfully avoiding supervision. So a lot of times with absconding, what you'll see is a court look at the totality of the circumstances and say, well, this person's missed all these different appointments. They've been called numerous times. There's reason to believe that this person knew that the probation officer was looking for them, knew that they had these appointments. And when all of these things are added up, that this shows that they willfully avoided supervision or made their whereabouts unknown. And that's when you'll see absconding be used as a violation. But it is a tough standard, and there have been. This is something that we see the most hearings on in probation violation court.
Yeah, and I was thinking about how this is one of those areas in which the law and what happens in practice is sometimes not the same.
Mm-hmm.
The law makes it pretty clear on some of these of the somewhat bright line rules that this is absconding, this isn't absconding, and goes back and forth to try to figure out exactly, this concept of absconding. What you see in practice, or what it feels like in practice, is that when you look at the totality of the circumstances, the more due diligence that gets done by the PO, the more times it can be shown that someone didn't show up. And those things just keep going up and down and up and down, that the more things that rack up, a court's going to end up making a determination of absconding.
I agree.
Even though it may not just tailor itself perfectly to the case law, it's almost like there's this gut feeling of trying to willfully avoid the supervision. And all these things combined sort of add up to show this. And so it's kind of this sliding scale that seems to happen.
Mm-hmm.
So if you have somebody that constantly shows up to meetings, but then, you know, the officer hasn't done their due diligence like they're supposed to try to find them, but, you know, maybe their address is bad, then that may not be absconding. Or if you go the other way where, you know, they've always been able to find them at their house, but they're not great about coming to meetings, you know, that might go the other way. Or, you know, it's really all over the place.
Yeah, it is. And that's why absconding can be something that for prosecutors can be tough to prove. So a lot of times now the best practice, as you said, of probation officers is to really do a lot of investigation into this. Another substantive violation that is sometimes litigated is a new criminal offense.
Oh, yeah.
And so the language here is important about, it doesn't say a new criminal conviction, doesn't say being charged, it just says committing a new criminal offense. And so this one is one of the tricky ones.
Yeah.
You see
again, kind of like absconding, there's a difference between what's on paper and what's in practice.
Right.
This too has that element to it. What's in practice is if somebody's violated on a new criminal offense, a lot of times it will stay pending, you know, to see what happens with that criminal offense in a court of law if a charge comes about. And if that charge gets dismissed, a lot of times that violation goes away.
Right.
If they get convicted, the violation stays. That doesn't always happen. If it doesn't happen that way, then usually it goes to a hearing where the state has to prove that the criminal offense occurred. So it's almost like you're having this little mini trial.
Yes, I've seen this happen. Yep.
On the offense that's alleged, except what's interesting about a probation hearing is that hearsay is allowed to come in pretty freely.
Mm-hmm.
However, you as a defendant have the right to confront and cross-examine any key witnesses in the case, but that's not due to a Sixth Amendment reason. It's actually due to a due process reason, which is a really interesting distinction. So what that means is the Sixth Amendment guarantees you the right to confront and cross-examine witnesses, but not in probation violation hearings. It's a due process concern.
And one of the interesting issues with this is that even a person, there have been cases where a person has been found not guilty, or a case somehow is dismissed for various reasons, but that probation violation is still there because it's a separate issue. And that new criminal offense, that person can be found in violation of their probation, even if something else that doesn't result in a conviction with the criminal charge happens, because there's a different burden of proof. In criminal court, of course, is beyond a reasonable doubt. But in a probation violation court, it's really up to the judge to see, you know, did this new criminal offense occur? Now, a lot of times in practice, again, it's not just the fact that the person was charged, even though there's a violation normally given because the person was charged, because there's probable cause that a person, you know, when a person's arrested or charged with a criminal offense. But a lot of times it has to kind of go beyond the charge, but less than the conviction. So it's in this murky sort of area. And again, because it's in this murky area, it sort of just hangs out there a lot. But it is something that people need to be aware of, because you definitely can be violated for it. And it can activate or revoke and activate a person's sentence.
Just joining us here on WTOB, this is For the Record with Greenwood Law. I'm Dylan Greenwood here with Harold Eustache, and we've been talking about probation and probation violations. Talked about, you know, what happens when you're on probation, what happens when you ways that you can violate probation. Well, if you are alleged to have violated probation, you have the opportunity to go in front of a judge on a hearing, or you can just admit that it happened. If you deny, that's when you would go to a hearing, and if a judge finds you responsible for that probation violation, then either that way or admitting, then there's probably going to be some sort of penalty that's incurred. And there are a lot of ways in which that can come about. They range from, you know, obviously less severe to just outright revocation where you're serving your sentence. But it can be as simple as a modification of the probation. So let's say, you know, something isn't working quite right. You're doing a lot of the stuff correctly, but there's just one part, you know, through whatever it is that's going on in your life that's just not addressing something that it needs to, or you can't quite address it.
Right.
A lot of times a judge will take notice of that and say, you know, we want you to be successful. Maybe there's a different way to approach this.
And a lot of times probation officers too will come up with a way to modify it.
Absolutely. And judges definitely take the recommendations of probation officers seriously, because they are talking to the probationer a lot more than the court is. Another way that it can happen is an extension of the probation. So let's say you're on probation for 6, 12 months. All of a sudden you could be on it for another year. And, you know, just to show that you are able to do the probation like you should. Another way is to terminate it. So let's say by the time you alleged to have violated your probation, you've actually rectified whatever the alleged violations are. A lot of times a court will take note of that and just terminate the probation and say, you know what, they did it successfully. They've actually complied. Don't need to worry about this. And then some of the other ways, and then from there it goes up to possible confinement. Isn't that right?
It is. Well, in kind of going from the termination, you can terminate unsuccessfully, which matters because later on, if a judge sees that a person was terminated unsuccessfully for probation and they get a new criminal conviction, that judge may be less inclined to put them on probation. They can also be given a confinement in response to a violation. Those can go from essentially 1 to 90 days. And that CRV is what we call it, there's certain statutory provisions with the CRB, but essentially a CRV, it puts a person in custody, in confinement for a period of time set out by the judge that would eat into their sentence that they've been given, that active sentence, but would not necessarily terminate their probation unless specifically noted by the judge. So that person could do 45 days in custody, come out of that 45 days and still be on probation and be subject to the terms and conditions of that probation. And so again, the last one would be just revocation. They would have to, that probation would be revoked. Probation is essentially over. That person is going into custody to serve their active sentence at that point.
So hopefully, as our listeners can see, probation is certainly no walk in the park. There's a lot of requirements and constraints that someone put on probation will have to go through, and it is not a decision that is made lightly by anybody going through that process or facing that kind of time. So, obviously there are a lot of ways that can encroach upon one's life. So thank you for joining us here on WTOB on For the Record with Greenwood Law, and do not forget to join us next week. We're going to be discussing online and internet usage by teenagers. Here in the last little bit, Miss Childress, teenager down in Davidson County, thankfully was found safe, alive, down in Arkansas, and obviously she went through a very harrowing experience, a traumatic experience, but it appears a lot of what prompted that was online usage. And so we're going to be addressing some of those issues and how that can come about, whether it be human trafficking, kidnapping, potential other dangers that can come about from all of that. So Harold, let's sign them off with the Greenwood Law Bill of Rights.
Before we go, don't forget our Bill of Rights. I will not represent myself in court. I will not do law enforcement's job for them. I will not make statements when stopped by law enforcement. I will not consent to searches when asked by law enforcement, and I will not be my own star witness for the prosecution. Remember, everyone, it is not a crime to know your rights. This is For the Record with Greenwood Law, signing off.